who entered their papers into a peer-reviewed competitive process and have been selected because they are all excellent papers. I'm Nita Farahany. I'm a law professor at Vanderbilt Law School, and I'm honored to be able to introduce each person on the panel today and to play the role of making sure nobody speaks for longer than 10 minutes, of course, other than Professor Richard Epstein, who can simply talk as long as he would like and comment on all of these things. No, seriously, we'll also keep you to a time limit so that we can take some questions from the audience. We're going to go in alphabetical order, but I'm just going to briefly introduce each person, just tell you their affiliations, and if you would like to know more about them, I'm sure they'd be happy to do so, but we can move on to the substance. So we're going to hear first from Marie Gryphon and Theodore Frank on their paper today, and Marie is a senior fellow at the Manhattan Institute for Legal Policy, and Theodore is the founder and president for the Center for Class Action Fairness, and he also likes rainbows.
All right. Well, a very wise scholar once told me that you always start a PowerPoint presentation with a humorous cartoon, but we didn't do that. In the medical malpractice context, there's previous literature done on a database of all the Texas claims over the last 15 years. And a very interesting study was done, series of studies was done by Zeiler, Black, Silver, and Hyman, where they looked at the insurance limits and the settlements generated and compared the two. And you can see the ratios here. This is a ratio, the payment to limit ratio for a variety of different insurance policies. And for each of them, there's this tremendous spike at or near policy limits. And one of the co-authors, Charles Silver, suggested was that the policy limits, because of collectability concerns from going for excess damages against the underlying insured, that the policy limits act as a sort of de facto cap on what plaintiffs can settle for in medical malpractice litigation, and that therefore what's happening is that plaintiffs with claims that are valued higher than insurance limits are being systematically undercompensated, that they're all running up against this de facto cap, and that therefore if this is true, it has a series of implications that non-economic damages caps are completely worthless, that tort reformers are wrong, and so on. Now, as a tort reformer, I'm wrong often, but I don't like it. And we were kind of skeptical at Professor Silver's explanation for or theory of why the world looked like this. I mean, even if you believe that collectability concerns are an issue, even under their own data, you see there are a number of settlements that are well over policy limits, and indeed, for lawsuits that where the judgments are greater than policy limits, over half of them settle for greater than policy limits. So it's not the case that policy limits are acting as a cap. So what's happening there? Why do we see the spike? And what I thought was, and they suggest, the authors suggest that one reason that cases might settle greater than limits is a cause of action in Texas known as Stowers, which is Texas's version of the insurance bad faith refusal to settle, which is unique in Texas in a couple of ways. First, well, it's not unique, but in Texas it's different than the standard version because the plaintiff actually has a cause of action against the defendant's insurer for the refusal to settle. So if the plaintiff makes an offer of settlement, the insurer refuses, and then the plaintiff wins a judgment greater than insurance limits, the plaintiff actually has a cause of action, potential cause of action, against the defendant's insurer for the refusal to settle and can collect the excess liability as well as the potential non-economic damages, potential exemplary damages. And what Marie and I thought was that this might be distorting the underlying settlement dynamics so that the spike might be caused by other reasons. And we modeled this, and Marie is going to talk about that.
Okay, well, as Ted said, we were looking to solve a mystery. We thought that the inference from the spike at limits that 100% of these cases were being undercompensated because they reflected collectability concerns was unjustified. And we were wondering what other reasons cases might have for settling exactly at limits, as you saw in the Texas data. And so we did a little bit of microeconomic theory and determined that for a certain population of medical malpractice cases in Texas, given the Stowers rule, the cases would always settle at exactly limits. And that population is defined by this inequality. For all cases where the expected value of the underlying malpractice trial plus the expected value of the subsequent Stowers claim is greater than policy limits, which are themselves greater than the expected value of the underlying malpractice trial alone, all of these cases should settle if all the parties are behaving rationally at exactly limits. And the reason they will do this is because plaintiffs will not accept less than limits for cases falling within this group, and defendants will never pay more. And some pictures can help make this a little bit easier to process. As you can see, the dark dotted line is the expected value of trial in a non-Stowers world. So that just reflects the underlying value of the claim, that horizontal trial line. Above that, you see a shadowier straight line. That's the policy limits. So as you can see, we're looking at cases that satisfy the conditions of the previous slide. That is, the underlying trial is less than limits. The limits are less than that high curved mark you see there, trial and Stowers. The line is curved up there because as the offers get higher and closer to limits, refusal by an insurer to settle for that amount is arguably more reasonable. So your chances of prevailing on a Stowers claim are somewhat lower as a plaintiff's offer gets closer to the policy limits. Now what you'll notice is that there is a substantial discontinuity in the payoff associated with trial in a Stowers universe, right there at limits. That is, just under limits, trial in Stower pays the plaintiff more than settling, whereas just over limits, trial in Stowers pays the plaintiff less than limits because a Stowers claim isn't triggered by settlement offer over limits. And so all the cases following in that discontinuity should settle at limits. This is a slide showing the same thing from the defendant insurer's perspective. I'm not going to describe it because we're running really late. So anyway, we wanted to test our theory, build support for it through Monte Carlo simulations. And in order to do that, we needed to create a very basic game theory model of medical malpractice, litigation in the shadow of Stowers. So that's what you see here. The plaintiff either files or doesn't file a case based on whether the expected value is greater than 0 in our model. The plaintiff then makes a settlement offer which maximizes based on the factors that we've already touched on. And the defendant will accept or reject. They may reject if they are more optimistic about prevailing as the defendant in the case, for example. If the defendant rejects, the plaintiff either wins or loses. Note that in our model, if the plaintiff wins, we assign to that person not only the economic and non-economic damages in the underlying case, but also the expected value of a subsequent Stowers suit.
Now, what we did was, since there is no qualitative data out there, you can't really do an empirical study of this. So what we did was a Monte Carlo simulation. We would take a game with the same parameters, and we would run it 1,000 times. So any given probability, the plaintiff and the defendant would make an assessment of the case which was equal to the probability plus an error term with a mean of 0 and a standard deviation, had a bell curve. And what we found was that for a variety of different parameters, you could duplicate the sort of spike that you saw in the Texas data. So, for example, in this case, where the probability equals 26% and the damages are equal to $2 million, the Stowers claim is worth $2 million, and the insurance limits are $1 million, you see the spike. 29% of the cases settle at limits. You even see 9.5% of the cases settling above limits. And what's fascinating is, though, that the underlying malpractice claim is only worth $520,000, 26% times $2 million. The mean settlement here is for $830,000. So, in fact, for at least this parameter of cases, plaintiffs are being overcompensated. Now, we're not saying that all plaintiffs at insurance limits are being overcompensated, but what we are saying is that you can't tell whether plaintiffs are being overcompensated or undercompensated without knowing the underlying qualitative data, which isn't in the Texas database, of course. And a couple of other versions of this. This one was especially interesting because even though the probability is fairly low, because the damages and the expected, damages are high and the Stowers expected Stowers is high, what you find is that the mean settlement here is actually higher than insurance limits, which is fascinating because the probability is only 30% of success at trial. And what we ran a large series of runs on this, and what we found is that where damages are substantial or are above limits and any version of Stowers is substantive, you will find a probability less than 1 such that the expected value is greater than it would be if the case was a sure thing, and that's what this says in sort of symbolic logic there. Here's a version of that same thing here. We hold all the parameters constant, but vary the probability of success at trial, and you see this nice little hump here where the expected value is actually higher at low values of p, 20 to 30%, than it is later on as the cases asymptotically approach the insurance limits at the higher probabilities, as the defendant immediately agrees to give up the insurance limits. And we're out of time, but we have interesting results.
Sorry to be very vigilant about this, but
No
there's
problem.
so many interesting papers and so many interesting comments, I'm sure.